Judiciary, Civil, and Criminal Jurisprudence will come to order. We do not yet have a quorum, so we're going to wait to call roll until some more members of the committee show up. But in the meantime, we're going to operate as a subcommittee and would ask that Senator Crawford please come forward to present on Senate Bill 1007.
Good afternoon, Mr. Chair. Thank you for the opportunity to hear Senate Bill 1007 today. This bill is what we call the MUFIPA. We originally called it UFIPA, or UFIPA, but we're going to call it MUFIPA because it's the Missouri version. So this bill is to revise the Uniform Principal and Income Act, which was originally adopted in 2001. 6 states have already adopted some version of this, and 2 others, including Missouri, are looking at getting it done this year. So I'm going to give a very broad overview, and I have a witness or 2 that can help answer your specific questions. So this bill will provide updated and flexible accounting rules for trusts. As you know, different products have evolved over the years, and several years ago when this was originally done, we didn't have things like derivatives, asset-backed securities, hedge funds, and things like that. Well, now we do, and there's a question about how to account for that, whether it be principal or income. And so Senate Bill 107 will give estate planners the ability to tailor the terms of a trust to fit their clients' needs. And it also states that the trust will be governed by the law of the state where the trustee has its principal place of administration. This bill will allow the trustees to invest for the greatest possible return, regardless of whether it's in the form of income or growth of the principal. I might also add, we heard from the reviser of statutes, and we will have a sub, and all that sub is going to do is change on page 60, section 469.450. That section number is going to be changed to 469.446 because it's our understanding that .450 is not used anymore. So we will have a sub, but that's all it's going to do. And I'll try to answer questions, but I bet I've got a person way more qualified than me to do that behind me.
Any questions for Senator Crawford? Seeing none. Got off easy, Madam Chairman. And if you need to go to your hearing,
I am going to do that if you don't mind. Thank you, Mr. Chair.
Thank you. First witness in support. Witness in support of Senate Bill 1007.
Okay, there we go. Good afternoon, Mr. Chairman, members of the committee. I appreciate the opportunity of coming to testify with regard to the new Missouri Uniform Income and Principal Act. My name is Mike Maglieri. I chair the trust. I've chaired the trust committee for the Missouri Bar for the last 15 years. Served on the trust and probate committee for the last 40 years, and previously served as chair of the trust and probate committee and the founding chair of the estate planning division. So I hope I can give you a little bit of insight into this law. We passed the first law in 2001, and at that time the law was adequate. You know, we were talking about mutual funds under the 1986 Mutual Fund Act, and at that point we really weren't working with derivatives or asset-based securities so much, but things have really changed since then. What we did is we looked at the old law, we looked at a newer uniform version, but we customized it for Missouri. There were several sections that we looked at. We started working on this in 2018. It passed through division in 2019, and then we couldn't get it through, so we're back again asking for this MUFIPA to be addressed and that the legislature would enact it into law. There's a lot of different reasons for the Missouri Income and Principal Act to be updated. And so what I'd like to do is talk to you a little bit about your own estate plans. I'm sure you guys have revocable trusts that you're using, and most of the time when you have that revocable trust, you might make distributions to your spouse. And so in order for that to happen, under 2050-6B7 of the Internal Revenue Code, you want to get a marital deduction. In order to do that, most of the time, you'd be setting up a QTIP trust, Qualified Terminal Interest Property Trust. And under the terms of the Internal Revenue Code, you're going to have to pay all the income out to the spouse in order for that money to be, and the tax on that money be deferred until the second death. So it's a big thing to decide what is income, what's in that marital trust. You know, when you're funding your own trust, you might have investment incomes, but these days you might have derivative or asset-backed securities or hedge funds. You may have farmland with timber, a lot of different things that could be put in that trust. And so the definitions of what is income, what is principal are in this act. They've been expanded, and the big thing is that it gives the fiduciary flexibility to look at these different types of asset classes and decide whether it's going to be classified or characterized as income or principal. Really, the Act, I think, brings simplicity because at this point we've got so many gray areas in the Act that it's tough for accountants, lawyers, trust companies, banks to decide on some of these new type of assets. How do we classify them? Of course, it's important because if they're classified as income, you're going to have a possible 39% rate. Well, matter of fact, if you have more than $15,500 in an irrevocable trust, you're going to be at the top rate. If you're capital gain treatment with the principal, you'd be at 20%. And then, of course, we have our state tax that would be included in that as well. So, you know, hedge funds, exchange-traded funds, could even be digital assets. We passed an act a couple of years ago here in Missouri to deal with that. And we will make sure, and this is in accordance with generally accepted accounting principles. So in the Act, and it's a long Act, you know, I have to admit, the definition section has been expanded to cover some these types of assets.
Can I ask a quick
Yeah.
question? So the Act is a part of a uniform probate code provision that's been adopted by the Uniform Commission. Is that a correct understanding?
That's where we started, but then we took it through the committee for several years and customized it to Missouri law to make sure it comports with our case law.
Okay. Are there any, just to highlight for the committee, are there any major substantive changes that you would note? I'm not talking about like small technical changes to be specific to Missouri law. I mean, you took a different substantive direction than what the Uniform Commission did.
I wouldn't say that it's really a substantive difference. I'd say that we just accented different parts of the, for example, when we got to the marital deduction section, we said that you could receive a marital deduction if a trust was distributing between 3 and 5%. That was something that the Uniform Commissioners just left up to the state. We did that to harmonize it with the Treasury regulations to comport with marital deduction statutes.
Okay.
As an example.
Okay, great. Thank you.
So, you know, when a trust becomes irrevocable, the trust, unless it's a grantor trust, has to file a 1041 fiduciary tax return. And this law is applicable to all the nooks and crannies of that type of a filing. It gives guidelines to fiduciaries and for varied types of properties, and not just these type of investment properties, but for example, if you had a C corporation, you needed to comport with the qualified subchapter S trust rules, that's going to be applicable here and gives guidance regarding that. If there's real estate, whether it's farm or residential, it gives detailed guidance there. Even talks about water rights, timber rights, rental properties, insurance that might be in a trust, liquidating assets. And if there's an asset that is hard to value or to classify, then there's a default that generally 3% is going to be deemed to be income and 7% principal. There are special tax benefit trusts, and so you'll see that in the Act as a definition. As I already mentioned, a marital QTIP trust. But most of the time what people are doing these days is after the spouse dies, they're setting up separate trusts for their children and grandchildren, which are generation skipping trusts or dynasty trusts. And there we have another set of rules regarding the generation skipping, and those are incorporated into this act, whether it's a direct skip, a taxable distribution, or a taxable termination. The act also looks at trusts that would be set up, and if they're gifting trusts. And in that instance, a 709 gift tax return would have to be filed along with the 1041. It also addresses split income trusts for charitable remainder trusts, whether it's a unit trust or an annuity trust, and the necessity of filing a 5227 tax return. The Act looks at and defines and has many situations regarding receipts and distributions. That's important because the trust then will issue K-1s to the beneficiaries if there is income, and many times the trust would be benefited and the whole estate would be benefited if you try to get that income out to the beneficiaries so they could be taxed at a lower rate. So the Act will help Missouri taxpayers without losing any revenue from the state of for the state of Missouri. So I just had a client in last Friday who had 25 rental properties and kind of had a strange situation. They wanted to keep this rental property in trust for several generations, and they wanted to get this $20,000 a month income out to the beneficiaries. But I questioned them and said, well, what if that some of this property has to be sold and you don't have the rental properties anymore and there's just a bunch of cash there? How are we going to deal with that? Well, the code talks, or the Act talks about an income-only trust and the ability for the fiduciary to convert it to a unit trust. A unit trust, to remember, is a trust that has a certain amount in there, and then you pick a rate that you want the payout to be. For example, if you had $1 million and you had a 5% rate, you have $50,000 a year. And you could convert an income only to a unit trust. And under this Act, there are details regarding the unit trust policy, the notices that have to be given to the beneficiaries, things that are prohibited from being converted. For example, if you did have a charitable remainder unit trust, you've got a tax deduction that you've calculated at the beginning of that process, and the Internal Revenue Code will not let you convert that because your income tax deduction would be, affected. Then, since the Act was in place in 2001, in 2005, we reworked our Missouri Uniform Trust Code. So it went from a small version to a pretty long, intricate version. And since then, we've had many significant changes that the legislature has approved, primarily from 2010 to present. We have a classification of people that can direct the trustee called trust protectors. So that's 808 of the Trust Code. Very significant. The new Act deals with that. We enacted the ability to have non-judicial settlements. So family members, for example, can come together and agree after notice is given. The Act talks about that. Of course, we had the Missouri Fiduciary Access to Digital Assets. The decanting statute, which allows a trustee to take a trust asset and reform it. And then we have our qualified spousal trusts, which are used all the time in Missouri, which allow husband and wife to have separate shares. If one of the spouses dies, that share can become irrevocable, and there's income and principal decisions that have to be made. So the fiduciary's power to adjust is very important. That's in this Act, coordinated with the Missouri the Missouri Prudent Investor Act. And there are several, there's lists there, maybe 8 to 10 things that were required if you're to adhere to the Prudent Investor Act. Typically and generally, it's that you'd have a total return trust. Every asset in the trust wouldn't have to do well as long as the total return was reasonable. That's already in Missouri law, and so we want to bring harmony to that. The receipt from businesses, so you may have not only farms, but you have corporations, limited liability companies in someone's trust, and the receipts and the distributions of those businesses and the classification of when it would be income or principal is very important. The Act covers all that. The fiduciary duties are detailed, and what this will do is let the Missouri legal community really customize the drafting. We have all kinds of different situations and different types of subtrusts that are created, and so this act will really bring clarity. This has been approved by the Missouri Bankers Association, of course, the Missouri Board of Governors, and we made sure that it was consistent with the Missouri common law. That's probably, unless we dig down into some really, into the weeds, that's the benefit of the act.
Any questions for the witness? Seeing none, thank you for your testimony. Since we do have a quorum present, I am going to, before we have the next witness come up, make a motion that we go into executive session. Do you have a second? It's been moved and seconded. Madam Secretary, please call the roll.
Senator Lukemeyer,
Here.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent.
We do have a quorum. I would now make a motion that we go into executive session. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Those contrary, no. The ayes have it. We are in executive session. I would now make a motion that we bring up for the committee's consideration Senate Bill 864. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. Senate Bill 864 is Senator Thompson Rehder's bill that modifies provisions relating to costs and fees in divorce proceedings. It stipulates that the defendant would be responsible in paying the court costs and fees of the petitioner in the event they were non-compliant with the court's order. And I don't know, Senator Rehder, if you want to add anything to that.
I think so. We passed it out unanimously last year, and we didn't make changes, so I'm hopeful that we will pass it out the same this year.
Great. Any further discussion on the bill? Seeing none, I would now make a motion that we do pass Senate Bill 864. Do you have a second?
Second.
It's been moved and seconded. Please call the roll.
Senator Lukemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rehder,
Aye.
and Trent.
By your vote of 4-0, you have voted do pass Senate Bill 864. I would now make a motion that we bring up for the committee's consideration Senate Bill 1221. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. For the benefit of the committee, this is Senator Trent's bill that has some modifications relating to estate planning. We do have a Senate committee substitute that the members should have. All it does is combine with Senator Trent's bill the language from Senator Coleman's 988 regarding qualified spousal trusts. The language is unchanged in both the bills. We're just rolling them together into a new substitute that combines both bill numbers together. Is there any discussion? Seeing none, I would now make a motion that we adopt Senate committee substitute for Senate Bill 1221. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. You've adopted Senate committee substitute for Senate Bill 1221. I would now make a motion that we do pass Senate committee substitute for Senate Bill 1221. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Lukemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent.
By your vote of 4-0, you have voted do pass Senate committee substitute for Senate Bill 1221. We are going to leave the board open for any members that come into the hearing before we adjourn if they want to cast their vote. But given that we have no further bills to exec on, I'm now going to make a motion that we exit executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are out of executive session. We are back on Senate Bill 1007. Next witness and support.
Mr. Chairman, members of the committee, my name is Andy Briscoe. I'm the registered lobbyist for the Missouri Bar. We'd like to go on record in support of this measure and thank Senator Crawford for bringing it forward.
Any questions for the bar? Seeing none, thank you for your
Thank you.
testimony. Further witnesses in support.
Mr. Chairman, members of the committee, David Kent, registered lobbyist for the Missouri Bankers Association. Also want to go on record in support of the bill.
Any questions for the bankers? Seeing none, thank you for your testimony. Further witnesses in support. Any other witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, that will conclude the hearing on Senate Bill 1007. Next up, Senate Bill 869. Senator Moon, whenever you are ready.
Good afternoon, Mr. Chairman and members of the committee. I'm Mike Moon. I represent the Missouri 29th Senatorial District. Here today to present to you Senate Bill 869, which otherwise known as Haley's Law. Appreciative of Senator Thompson Rehder's efforts last year in getting some lifetime protection orders instituted in law, and we're building upon that effort, and hopefully we'll get that done this session. Currently, there's a second motion after an individual is charged and convicted to make a motion for lifetime protective orders, and then periodically they will have to be renewed. In this particular law, if this is passed, 869 will allow for, at the time of sentencing, for the lifetime protection orders to be made in that particular case, and they won't have to face their accuser again to renew those orders. And I think that's significant, because a lot of these individuals who have been subjected to traumatic incidences and dangerous felonies is what we're looking at here. It doesn't make sense to require them to go back and face their attacker numerous times in the future. I want to give just briefly an account of someone that I know who has gone through some trauma in her life. She was estranged or divorced from her husband, and he physically, sexually assaulted her. There was a charge, a conviction, and it took years to get a protection order in place. And just reliving that trauma time after time, going to a courtroom. In fact, to make even matters even worse, because of the time that took place between the conviction and the protective order being in place, a judge who was not all too familiar with the case asked this woman, "What did you do to deserve to be raped?" As if she caused it. And so we shouldn't put these individuals through that type of trauma again and again and again. Today I have an expert witness. Her name is Kaylee Kozak. So if there are no questions, or after the questions, I'd like to introduce Kaylee Kozak to give her account and to plead her case as well. So, Mr. Chairman, are there questions that I might be able to answer?
Senator Moon, just one question that I have. So and I should have looked this up before the committee hearing. For non-lifetime orders of protection, do you know what the current time frame is for how long those normal protective orders are good before they expire?
If I'm not mistaken, about 180 days.
Okay, so it's that short?
Yes.
Okay. All right. Thank you. Any further questions for Senator Moon? Seeing none, first witness in support.
Kaylee Kozak. If you'll tell them who you are, where you're from.
Hello, members. My name is Kaylee Kozak. Just got in from Arizona not that long ago. I would first like to start by thanking the bill sponsor, Senator Moon, for sponsoring this bill, and I would also like to thank the chair for hearing this bill. And I would like to thank you for your efforts that you've put forth to help protect victims of dangerous crimes, specifically sexual crimes. Every 68 seconds, an American is sexually assaulted. And every 9 minutes, that victim is a child. In my quick 21-hour trip to Missouri from Arizona, approximately 1,200 Americans will have fallen victim to sexual crimes. Statistics say that 1 in 4 will be sexually assaulted in their lifetime. Look around this room. There are many survivors amongst us. and not just survivors of sexual abuse, but also survivors of other heinous crimes. I stand or sit here today before you as many things. I'm a proud wife, mother to 5 beautiful children, college graduate, Jesus-loving, God-fearing woman who is passionate about pursuing proactive legislation to create actual solutions. And I am also a survivor of childhood sexual abuse. To have a complete understanding of how we came to this place, I do feel it is important to provide some insight, and I would like to share just a small piece of my story with you. At the tender age of 12, I was sexually abused by my PE teacher, who was also my club soccer coach. This man worked overtime to groom and manipulate every member of our community and every community that he was a part of. I simply existed, trying to survive my 6th and 7th grade year, desperate for someone to save me, but no one could because they didn't know that there was anything to save me from. The abuse came to a halt my 8th grade year because this man no longer had access to me due to me not switching schools and switching soccer teams. 9 months went by before I unexpectedly ran into my perpetrator on a soccer field. I froze when he approached me, unable to comprehend anything that he was saying until I found the words, "I hate you for what you did to me." For the first time ever, I saw fear in his eyes, and he told me that he would hurt me and my family if I ever told anyone the things that he had done. As I watched him walk away and join his girls' soccer team that he was currently coaching, I wonder if any other girls on that team hated him for the same reason that I did. As I proceeded to join my parents, I had to detach from what just happened to me. No one would believe me if I told them the things that he did to me because everyone loved him. He knew everything about my life, he had access to every single area, and he set it up to be that way. It wasn't until my freshman year of high school at 14 I mustered up the strength and the courage to turn him in, and that was when the real hell on earth began. A one-party consent call was conducted, and my perpetrator admitted to everything that he had done to me. The next day, he was arrested and charged with 4 counts of sexual abuse, 2 counts of child molestation, attempt to commit sexual conduct, and luring a minor for sexual exploitation. Just as I suspected, after the arrest, so many doubted that he was capable of doing these things to me. Even my parents had a hard time believing that he had done these things. The soccer community and even the school community stood on his behalf. To say my family and I were devastated was an understatement. So many horrific things happened after I turned him in. I often wondered if I made the right choice because more days than not, I feel like I didn't. But even at the age of 14, I knew that if going through this hell meant sparing someone else of having to endure this trauma, then it was worth it. If this hell meant saving one other girl from being victimized, then this hell was worth it. It was a year before he was prosecuted, and he was facing 25 years in prison. Ultimately, my parents had agreed on a plea deal with the hopes of sparing me any further trauma. It consisted of 6 months in jail and 2 terms of lifetime probation. He never even went to prison. My parents accepted this because they were told that this would be valid for a lifetime. After my case closed, this chapter of my life closed, and I buried this file deep in my drawer and deep in my heart. Life does not slow down because our world stopped. And like every other victim, I learned how to continue moving forward. Until January 2020, when I received a phone call that changed everything. I was notified that my perpetrator had motioned to have the terms of his so-called lifetime probation lifted. And due to his good behavior and completion of treatment, he was eligible. When I asked what protection was available for me, I was informed that there was no such thing as post-probation protection. I could not comprehend anything that was happening. How is this even possible? He asked for lifetime probation in lieu of extended prison time, and now he wanted that to be lifted. After 15 years, I had to reface this man in court and ask the judge not to lift his probation because if he did, I would be left with no protection. And this is how Kaylee's Law came to be. Had this law been in place, I would have never had to reface my abuser in court after a decade to ask for this protection. Kaylee's Law provides victims of most notably sex crimes, some domestic crimes, and dangerous crimes an injunction or an order of protection that is valid for their natural lifetime, regardless of the perpetrator's probation status or their sex offender status. It makes the crime itself adequate enough to obtain this order of protection. No victim should ever have to experience the things that I've had to experience, and no one should ever feel that they will lose protection from the individual who has already harmed them. Just because things change for the perpetrator does not mean that things should change for the victims. Victims are forever impacted by what was done to them, and they will endure so many things as a result of someone else's selfish, inexcusable actions. Although the law varies in each state, the overall concept is the same. protecting victims for their entire life. Currently in Missouri, there are two types of protective orders, an ex parte order and a full order. Sadly, even a full order is not to exceed 10 years. And although it can be set to automatically renew, in order to obtain this protective order, a hearing must be set. This is not only re-traumatizing victims, but also re-victimizing them. By enacting this law in Missouri, as the bill states, the court shall have jurisdiction at the time of sentencing to enter a lifetime protection order prohibiting the defendant from having contact with the victim if found guilty of a dangerous felony. By serving at the time of sentencing, victims are being spared the future trauma that may surface. In Missouri, sex offenders are categorized by 3 tiers. Sex offenders deemed a level 1 are required to register for 10 years. Sex offenders deemed a level 2, 25, and sex offenders deemed a level 3, lifetime. However, it is important to note that there is, in fact, a process for removal from the registry. And if and when that happens, then what is left in place for the victim? Currently, they would have to petition the court and attend a hearing to ask for an order of protection. According to the recent statistics in Missouri, 67% of victims are under the age of 18 at the time of the offense, and these victims still have so much of their lives to live. They should not have to ever worry that their lives will be disrupted or affected at the hands of the person who has already caused them so much harm. Victims not only have to cope with the trauma of the crime itself, but also must cope with the process and the treatment they receive from the criminal justice system. We must start prioritizing the needs of the victims and be proactive on their behalf rather than focused on having to be reactive of the perpetrators. Arizona was the first state in the nation to pass Kaylee's law, followed by Wisconsin, and is now going through the legislative process in several states across America. Kaylee's law has had complete bipartisan support and has been signed into law by both a Democrat and Republican governor. In the first year Kaylee's law was enacted in Arizona, over 1,000 victims have been able to obtain this order of protection. That many in 1 year. That's one state. By supporting this, you can be the reason that victims have this additional protection and don't have to worry about their lives being uprooted again. Just imagine how many victims of this heinous crime could benefit from this protection in your state. This could be a positive impact on their life. When I began pursuing Kaylee's law, I had no way of knowing how needed it was, not only in Arizona, but across the nation. Everywhere I go, I meet people who have not only been impacted by some sort of sexual crime, but other crimes, and it is absolutely heartbreaking. This has not been easy, and in fact, it's been more defeating than anything for so many reasons. Ironically, I know this feeling and experience all too well, as it is relatable to what I went through when I was just 14 years old. But if fighting for this spares other victims from this hell that I have endured, then it is worth it. I will never stop fighting for victims and survivors because you still matter. Thank you for the opportunity to be here, and I am available for any questions.
Thank you for your testimony, and thank you for your courage coming forward. I know that this is very difficult. If you have not yet, if you could please fill out a witness form for the committee just so we can register your presence here at the hearing, we'd appreciate that. Any questions for the witness? Seeing none, thank you for your testimony.
Thank you very much.
Next witness in support of Senate Bill 869.
Daryl Moore, Association of Prosecuting Attorneys, Office of Prosecution Services. I'll be brief. We support the bill.
Any questions? Daryl, I wasn't expecting you to be that fast. Didn't even get through a conversation with the vice chairman. Any questions for the prosecutors? Senator May.
Yeah. So this is, I was trying to look it up, but I got distracted. RISMA 455.098. Is that under sexual offense? Is it only?
This bill, as I understand it, covers the dangerous felonies, and I've just come from an aggressive hearing in the House, Senators, so I'm not sure I could list for you all the dangerous
Right.
felonies other than murder, robbery,
Yeah,
rape.
so that was my concern. Is this pertaining to all dangerous felonies, or is this pertaining to just dangerous felonies in reference to sexual assault?
No, it's all dangerous felonies as defined by statute.
Okay, very good. Thank you.
Any further questions for Daryl? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 869.
Lisa Panett with Armor Vine, and we just want to come and voice our support.
Any questions for Ms. Panett? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 869.
Good afternoon, Senators, and thank you for the opportunity for me to speak with you this afternoon. My name is Timothy Faber, and I'm here today to express support for Senate Bill 869. It is my understanding that a victim of a dangerous crime is already allowed to seek a restraining order against the one who committed the said crime. However, obtaining the restraining order often requires additional time and trauma. This bill allows for the protection to be put in place at sentencing, so there is no gap in the safety and well-being of the petitioner. Under this legislation, the petitioner, victim, sometimes referred to as survivor as well, would not have to file for protective orders once the trial and conviction are completed. Every time a petition is made, there is a hearing to determine the validity, and again, more time. The protective orders are, at most, 10 years, sometimes as short as 2 years. As Senator Moon stated earlier, initial protective orders are 6 months. After that, you can go for longer period of time, which is sometimes up to 2 years, but at most 10 years. So every few years, and perhaps more often, a person must file again. They just get on a good path of healing from their trauma, and they have to relive it all over again as they file another petition, and likely attend a hearing where they're questioned as to whether and why the order is needed. It puts the victim on trial again and again, rather than recognizing that they are not the guilty party. Heaven forbid that a person miss the opportunity to refile a petition for the protective order. Then the perpetrator, a convicted felon, would be free to contact their victim again, obviously leading to increased stress, fear, and anxiety. This is compounded by the fact that a victim may not know that the offender has been released. Missouri Statute 595.209(5) does guarantee the victim's right to be notified when an offender is released, paroled, escapes, or even has a parole hearing scheduled. However, the victim must file with the appropriate person or agency with their current addresses, electronic mail addresses, telephone numbers, addresses, electronic email addresses, or telephone numbers at which they wished notification to be given. That's in Statute 595.209(18), paragraph 3. But haven't we all forgotten to update information from time to time? And even filing updated information over a period of years or even decades forces that victim to relive the trauma again and again. This legislation would allow for a lifetime order of protection and more truly fulfill the intent of Statute 595.201(2), paragraph 9, which states that the victim is to be free from intimidation, harassment, and abuse in any related criminal or civil proceeding, and the right to reasonable protection. I encourage you to help those who have been victimized by dangerous crime to heal, to be free from the hassle and strain of revisiting their trauma every time they change their email, phone number, or mailing address. I encourage you to help these folks move on with their life by not requiring them to file again and again and again to renew orders of protection, wondering with each filing whether that order will be extended. I encourage you to support this legislation, and I'll try to answer any questions that you may have.
Any questions for the witness? Seeing none, thank you for your testimony, and if you haven't yet filled out a witness form, if you could, perfect. Great. Thank you for your testimony. Further witnesses in support of Senate Bill 869? Seeing none, any witnesses in opposition to Senate Bill 869? Seeing none, any witnesses for informational purposes only? Seeing none, Senator Moon, any concluding remarks?
I failed to mention there were at least 2 Missouri residents who wanted to come testify, but due to extenuating circumstances, they were unable. So just in case they're wondering if any Missourians have been adversely affected by what we're talking about, they were. So thank you, Mr. Vice Chairman.
Thank you, Senator. That concludes. Oh, do you have a comment? Senator Rehder.
I was just going to piggyback on that and say that I have had some women who have who actually testified last year when we worked on some of this language that are in Missouri ladies that are very in strong support, and I know personally this would be very, very helpful.
I concur. Thank you both. Moving forward, that concludes the hearing on Senate Bill 869. Moving to Senate Bill 1370, we have Senator Black here. Take to the witness stand and proceed when ready.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Rusty Black, and I represent the 12th Senatorial District. Thank you for taking time to hear Senate Bill 1370. The bill includes within treatment courts in the state of Missouri a specific authorization for what would be known as mental health courts. I'm sure most of you on the committee are familiar with the work of what drug courts have done, and this would add another element to those types of treatment courts. For those who are not familiar, treatment courts are defined as a specialized non-adversarial court division with jurisdiction over cases involving substance-involved offenders and making use of comprehensive supervision, drug and alcohol testing and treatments. Current divisions include Adult Treatment Court, DWI Court, Family Court, Juvenile Court, Veterans Court, and this would add to the list Mental Health Court. Mental Health Court would be defined as a treatment court focused on addressing the mental health disorder or co-occurring disorder of defendants charged with a criminal offense. Our Substance Abuse Task Force heard testimony from administrators of treatment courts that provided that these courts are a cost-effective way to avoid incarceration, reduce recidivism, offer offenders a way to remain connected to the community, and reduce the amount of babies who are prenatally exposed or addicted to illicit substances, reduce crime, family separation, ensure child support payments are made on time, and avoid pain and societal cost resulting from drug and alcohol use and mental health disorders. Thank you for your time. I'll be happy to try to answer a question or two. I know behind me there are people that know this lawyer talk, Vice Chair.
Thank you, Senator, for the explanation of the bill. Any questions that I have, I'm going to reserve for the experts behind you, but does anyone have any questions for the sponsor? Seeing none, call your first witness in support, have them fill out a witness form, and proceed when ready.
Good afternoon, Mr. Chair, members of the committee. Eric Jennings, Government Relations Counsel for the Supreme Court. And with me I have Judge Alan Blankenship from the 39th Circuit, who has much more extensive experience than I do, in addition to the lawyer speak, and can answer any questions for you on this.
I'll be happy to answer any questions you have. I am Alan Blankenship, a circuit judge from the 39th Circuit, Stoneberry and Lawrence counties. I previously served as chairman of the Treatment Court Committee when House Bill 2, which is now memorialized as in Chapter 478, was crafted. And so I'm partly responsible for the omission of mental health treatment courts at the time. I now serve on the Treatment Court Coordinating Commission, so I speak from that perspective as well. And for many years, I teach on treatment courts nationally for the American Bar Association and the National Treatment Court Professionals Association, known as All Rise. Back in 2017, 2018, when we were crafting what's now Chapter 478, we had a discussion about whether to include mental health courts at the time or not. We chose not to, primarily because we were wanting to basically consolidate what was on the books existing and not add in any new concepts at the time. And in hindsight, we were wrong. We should have included the language at the time. At the time, there were just a handful, there's still just a handful of standalone mental health courts, but we are seeing increasing gaps in the offenders that appear before us who are not incompetent to proceed, but don't have also a substance use or alcohol use disorder coupled with a mental health disorder. So where there's currently a gap that would be well served by standalone mental health courts. Currently, funding through the Treatment Court Coordinating Commission cannot be used for a standalone mental health court program. We do provide funding for what we call co-occurring disorder programs, which is the mental health disorder coupled with alcohol or substance use disorder as kind of a track within existing adult treatment court programs. And we certainly address mental health disorders in the Veterans Treatment Court programs, but absent that, we now have currently a gap. I know our circuit, we've started the discussions about developing up mental health court programs for our circuit, or at least starting out with a track, a co-occurring track. But right now, to properly use the coordinating fund money, we need it coupled with an alcohol use disorder or mental health, or substance use disorder. So we do have presently that gap. Eric and I were talking the other day, and I think Eric mentioned sometimes you stick around this town long enough to fix your own mistakes. And I kind of looked at this as coming within that square within that. This is an opportunity for me being here with you to answer questions that you may have, and maybe a chance to fix a mistake that we made back in 2018 by not including it at the time when it was first passed as 478.
Any questions for the witness? Senator Schroer.
Anyone can answer this one. I'm looking at the fiscal note here, and one of my biggest gripes with the way we do the fiscal notes in the state of Missouri doesn't really take into account the money that we will save by implementing something like this. And I know with the treatment courts and my own personal experience when I did criminal law, I think it saved a lot of money for our criminal justice system by avoiding the housing of these individuals and recidivism rates, so on and so forth. Do you think that any of the courts, any of the circuits that are going to implement the mental health treatment court will ultimately save our state some money, and why or why not?
Absolutely. Treatment court programs, whatever iteration they are, whether it's Veterans Treatment Court, adult drug, DWI, juvenile, family, etc., so long as they maintain a fidelity to the model that's for that particular program, day in, day out, all these studies show that there is a definite substantial cost savings by utilizing this approach. And if I can kind of step back, by including it in the statute, not only would it allow treatment court funding, existing funding, to be utilized for this type of program, but it also, along with it, will allow oversight and standards to monitor these programs to make sure that they operate with a fidelity to the mental health court model that's based on research as to what works.
Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 1370.
Okay, hi. My name is Madison Ekrit, and I'm a lobbyist with the Penman Group, and I'm here on behalf of Empower Missouri and the Missouri Association of Public Administrators, and wanted to voice our support for this bill and thank the sponsor for introducing it. It's like already mentioned, it's an effective investment. It's effective in treating the underlying problem by providing services and supports to folks and prioritizing rehabilitation over punishment. And also, this mental health treatment courts foster an environment where that folks can work together across disciplines to ensure specific needs are being met for each person, and it results in better outcomes. For many of the other reasons mentioned prior to, we voice our support for both Empower Missouri and the Missouri Association of Public Administrators. Thank you.
Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 1370? Seeing none, any witnesses in opposition for Senate Bill 1370? Seeing none, any witnesses for informational purposes on Senate Bill 1370? Seeing none, Senator Black, any concluding remarks?
No, thank you very much for allowing me to present the bill.
Thank you. This will conclude the hearing on Senate Bill 1370. Next up is Senate Bill 1220. Senator Trent, whenever you're ready.
Thank you, Mr. Chairman, members of the committee. Curtis Trent representing Senate District 20. Senate Bill 1220 basically has a couple of changes here. First, it would align the minimum juror mileage allowance with the mileage rate for state employees. Secondly, juror compensation and mileage allowances for jury service currently vary by county, but state law sets a minimum statutory floor, which is $6 per day and 7 cents for every mile traveled from the juror's place of residence to the courthouse and then returning. Next, state law also authorizes two options for additional compensation. The first option allows any county or the city of St. Louis to provide additional daily compensation and mileage allowance for jurors. If a county pays an additional $6 or more in daily compensation, the total compensation would be at least $18, with the state of Missouri reimbursing the county for another $6 in compensation. Under the second option, Greene County and now Clay County could authorize payment of $50 per day for the third day and following days of jury service. So essentially they would serve for free the first 2 days, and then jurors that are there longer than that could receive $50 per day. Eventually, I also want to add, though, we plan to have a committee substitute, which all that would do is alter the authorizing authority from what this language says is the court en banc would decide which compensation option to pursue. We would change that to the governing authority of the county because they have more information about the budget of the county and what they can afford. So with that, I'd be happy to answer any questions the committee might have.
Any questions for Senator Trent? Seeing none, first witness in support of Senate Bill 1220.
Mr. Chairman, members of the committee, Eric Jennings again. This is another item put forward by the Judicial Conference of Missouri. As Senator Trent had mentioned, we currently have the base, the foundation for juror pay. We have a secondary option where counties can pay more. And then we have a third existing option, but that third option is only available to Greene County or to any other counties that fall into that same classification, which Clay County has moved into now. At its core, the legislation would afford that third option to any county in the state, that they would be able to use that in the same way if, looking at their own particular circumstances, they would see the value in doing that. The other change that's included in it, and it was item mentioned in the Chief Justice's stated the Judiciary address, the mileage, it would go ahead and peg that to the mileage rate for state employees. I cannot tell you exactly how far back this mileage rate, particular statutory mileage rate goes. I know it goes farther back than 1989. We have not changed it since then. So be glad to answer any questions. I do have or have had a discussion with the court staff down in Greene County to look at the numbers on this. It is something where they have experienced a savings over the years that they've had this in effect. It is not, although it may seem counterintuitive, it is not anything that causes an issue with the jurors themselves. They are, by and large, willing to forego those first 2 days, knowing that greater compensation is provided to those who are serving a much longer period of time on an actual jury. So,
thank you for your testimony, Eric. I'm looking at this. So the way that we're fixing the mileage issue, it looks like, which I agree with, is we're just cross-referencing the state statute that deals with mileage for state employees. So essentially, as mileage rates change over time for the statute is going to automatically keep up with that.
Correct.
So we're not back here, because you're right, the last time, 7 cents a mile, this statute was updated quite a while ago, or the last time it was updated was quite a while ago. So, great. Any questions for Eric? Seeing none?
the only other item I might mention, you'll notice there's a large section that repeals a good portion of 488.040. We have our juror compensation stuff enacted in 2 spots. Now, currently it's identical, but at some point in the future it may not. It's in the court cost chapter, but also in the jury chapter. This would eliminate the language in the court cost chapter and just do a cross-reference back to the jury chapter.
Okay.
So that we don't have
Eliminating the possibility
any possibility of conflict in the future.
Perfect.
So.
Yeah, makes sense. Any questions for Eric? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 1220? Seeing none, any witnesses in opposition to Senate Bill 1220? Seeing none, any witnesses for informational purposes only? Commissioner, come on up.
I'm Harry Otto, the Western District Commissioner of Cole County. Initially, when I looked at this, I saw where the court en banc could raise it to $50 a day. That was a concern for Cole County. We just recently completed a 4-week trial with 12 jurors and 2 alternates, Monsanto case, Roundup case. That satisfied, I guess, 3 plaintiffs, and we've got 17,942 to go. So we probably would not be inclined to go to $50 a day in Cole County, knowing what we face with the Roundup cases and maybe some other cases that are still around the corner. And my understanding is, as a result of some action of the General Assembly, we have those cases in Cole now, rather than perhaps St. Louis County, where Monsanto was headquartered. But I think the House bill mirrored the Senate bill, and the House bill also had the change of en banc out, commission in, with respect to making that decision.
And Senator Trent, that's the proposed committee substitute that you're going to ask to be execed out.
Yes, that we'll have that language when we get ready for exec.
Okay, and as I understand it from Commissioner Otto, Cole County would have no objections to the bill so long as it's the committee substitute version that reflects the commission makes that decision as opposed to the court en banc.
Correct.
Got it. Okay, great. Any further questions for Commissioner Otto? Seeing none, thank you for your testimony.
Thank you, Senator.
Any further witnesses for informational purposes only on Senate Bill 1220? Seeing none, Senator Trent, any closing remarks?
Thank you, Mr. Chairman, and the rest of the committee for your time and consideration.
Okay. No further business coming before the committee. I would now make a motion that we adjourn. It's been moved and seconded. We are adjourned.